In assessing the amount of damages payable, the courts use the following principles. A. The amount of damages is to compensate the claimant for his loss, not to punish the defendant. B. Damages are compensatory. The most usual basis of compensatory damages is to put the injured party into the same financial position he would have been in had the contract been performed. Now let us have a look at the kinds of damages. Liquidated and unliquidated damages. Where the contracting parties agree in advance the amount payable in the event of the breach, the sum payable is called liquidated damages. Where the amount of compensation claimed for a breach of contract is left to be assessed by the court, the damages claimed are called unliquidated damages. Unliquidated damages are of the following kinds: general or ordinary damages, special damages, exemplary or punitive damages, nominal damages. First, we shall discuss ordinary damages. Ordinary damages are restricted to the pecuniary compensation to put the injured party in the position he would have been in had the contract been performed. It is the estimated amount of loss actually incurred. Thus, it applies only to the proximate consequences of the breach of the contract, and the remote consequences are generally not included. Where the contract is one of sale, this principle calls for assessment of damages as at the date of the breach. Under a contract for the sale of goods, the measure of damages upon a breach by the buyer is the difference between the contract price and the market price on the date of the breach. On a breach of a contract to supply goods by the seller, the buyer is entitled to recover all the expenses of procuring same or similar goods. This was held by the Calcutta High Court in the case of Tata Iron and Steel Company Limited versus Ramanlal Kandoi. In case of non-delivery of goods, the damages are fixed on the basis of the price prevailing on the date on which the delivery is to be made, as was held by the Supreme Court in the case of Union of India versus Jolly Steel Industries Private Limited. Now, we shall discuss special damages. Special damages are those damages resulting from a breach of contract under some peculiar circumstance. If at the time of entering into the contract, the party has notice of special circumstances which make the special loss the likely result of the breach in the ordinary course of things, then, upon his breaking the contract and the special loss following this breach, he will be required to make good the special loss. For example, A delivered goods to the railway administration to be carried to a place where an exhibition was being held and told the goods clerk that if the goods did not reach the destination on the stipulated date, he would suffer a special loss. The goods reached late. He was entitled to claim special damages. Next, we shall discuss exemplary damages. Exemplary damages are awarded with a view to punish the guilty party for the breach. The exemplary damages have no place in the law of contract, since the object of the damages is to compensate the loss suffered by the injured party in case of a breach. However, exemplary or punitive damages are awarded in the following cases. Number 1, breach of a contract to marry. Number 2, dishonor of a check by a banker when there are sufficient funds to the credit of a customer. Now we shall discuss nominal damages. Nominal damages are awarded when there are no significant losses suffered by the plaintiff. These damages are awarded to establish the right to decree for a breach of contract.